The African American Legend series highlights the accomplishments of blacks in areas varied as politics, sports, aviation, business, literature, and education. We'll explore how African Americans have succeeded in areas where they've been previously excluded because of segregation, racism, and lack of opportunity. I'm your host, Dr. Roscoe C. Brown Jr., and with us today is Ted Shaw, Professor of Law at Columbia University, former Executive Counsel of the Legal Defense Fund. Welcome to African American Legends.
Thank you, Roscoe. Always good to be with you.
You're a fountain of wisdom about civil rights and legal activity. And right now we need a lot of wisdom and we need some luck. I'm talking about the voting rights case, dealing with changing of the voting requirements. It's in the Supreme Court. And I know this is something you were working on when we were the Legal Defense Fund. Tell us about the case. Tell us what you think the critical incidents are and how you think it might work out. Well, that's a lot to ask one man.
Yeah, I'll do the best I can with it. But let me once again say I'm always happy to be on your show and with you, no matter where it is and what time. The Supreme Court has before it this term, the 2012-2013 term, several cases involving issues of race, vitally important to the African American community, to people of color generally, and to the country. One of them is an attack on the constitutionality of parts of the Voting Rights Act, specifically what we call Section 5 of the Voting Rights Act of 1965, which has been amended several times. The last time was in 2007 when there was an expiring provision which either was going to be dormant or it had to be reenacted. Section 5 requires jurisdictions with a history of discrimination in electoral politics to pre-clear any changes in their electoral processes with either the Justice Department, Civil Rights Division, the Attorney General of the United States, or with the district court, federal district court in the District of Columbia called the DCDC. And some people wanted it to expire, and there were those who felt that it was very important that it be extended further. They were concerned about things like, for example, voter ID requirements that were being implemented in many jurisdictions, including some of the southern jurisdictions, which would have the effect disproportionately of forcing some African Americans, Latinos, poor people, older people out of the voting processes. And we did get an extension of Section 5. It was challenged, as we knew it would be. A case went to the Supreme Court a couple of years ago, and it was ably argued by David Odegbile, who at that time was with the Legal Defense Fund, and he won it. We won it. And in winning
how much did you win it by? 5-4?
Well, it was 5-4, and the Chief Justice of the Supreme Court, Chief Justice Roberts, John Roberts, even though he voted to uphold it, made it very clear that he really had doubts about its continued viability and constitutionality. We knew that he was hostile to the act, and he invited Congress to revisit it and to change it. Congress hasn't done that. There's a case out of Shelby County, Alabama, that's before the Supreme Court now, and it will be decided sometime before the term is over in late June or early July, depending on how long they go. And there's a good chance that this Supreme Court is going to strike down Section 5 of the Voting Rights Act.
Now, what logic did he use to say that this really goes beyond the Constitution?
Well, the argument against the extension of Section 5 in the form that Congress passed it is that originally the southern states that were found to need coverage were states that had all these discriminatory practices. Black folks didn't have the right to vote. Part of the coverage formula originally was a percentage of black people who were registered or minorities who were registered. There had been a long history of exclusion of African Americans from the ballot. The argument that they're making today is you no longer have that exclusion, that was a long time ago, that there's no justification for this kind of intrusion into the affairs of any given state or its subdivisions, its political jurisdictions. We don't need it anymore. And they point to President Obama's election and now re-election as proof that the electoral processes no longer are plagued with racial discrimination. That's the argument against it. Of
But
course, there are
isn't the
arguments for it.
Republicans and the conservatives point that this lack of identification leads to voter fraud, even though there's not any real evidence of that? Isn't that what they're using to appeal to the Supreme Court?
Well, you know, the voter fraud piece is the justification for the voter ID requirements, and that may be just one of the things that a jurisdiction could do if it's covered by Section 5 that would require pre-clearance. There are some jurisdictions, a number of them, that don't have Section 5 coverage that have adopted voter ID requirements, like in Indiana, for example, and the Supreme Court upheld it. Tragically, I think, and unfortunately, we have, some of us have described this voter ID scenario as a solution in search of a problem. In-person voter ID fraud is almost non-existent.
Well, the problem is that most minorities vote for Democrats.
Well, you know, I think that there's a lot of truth to that. The problem is that largely Republicans have been trying to adopt these voter ID requirements because they think, I believe, that that it's going to have an impact disproportionately on people who vote for Democrats. Other people think that they're doing it because of racial motivations. Doesn't matter to me. The impact is that many black and brown people, but not only that, poor people in general, you know, are impacted disproportionately. A lot of people say it's easy to have a driver's license. Most of us have them. But, you know, a lot of people thought that everybody would be able to escape easily from Katrina until we found out that poverty impacts many people in ways that we don't see. And people are trapped just as they were in New Orleans. People are also trapped in a kind of poverty that often means that they don't have governmental ID. So, you know, homeless people have a right to vote if they're American citizens. You know, so I'm really opposed to any of these schemes that result in less participation of people in the electoral processes, but some people want that to happen because they think that their side will win. That's tragic.
What evidence do you need to show to register for vote?
Yes.
How do you know? They have these voter registration campaigns, people sign sheets. How do you know that that person is a citizen?
Well, you know, it varies. So, for example, in Texas, believe it or not, you can show a you know, some kind of gun permit, and that's proof for purposes of registering to
But
vote.
it doesn't show you're a citizen.
Well, you know, but that's what Texas said, and you know, but yet you know, students can't show their college ID. So black students at Prairie View College, for example, you know, they can't use their college ID, and people can use gun permits. Obviously, birth certificates, you know, passports, et cetera, but a lot of poor people don't have passports. They're not traveling outside of the United States, many of them. And a lot of people don't have driver's licenses. And to get it, for some people, believe it or not, may be a burden. And some people can't find their birth certificates. My grandmother, lifelong New Yorker, God rest her soul, you know, her birth certificate was destroyed, the original, in a fire in Brooklyn. We know she was born in Brooklyn, but she was not able to get a birth certificate, even though I have papers that I could show now where she was trying to find a copy of her birth certificate. That's not unusual. So, you know, there are a lot of people who are being left out of these processes.
But where you have a country where a number of people are immigrants who have come in and don't have papers, how do you really know that they are citizens and are eligible to vote?
Well, you know, most of us, when we go to the polls, you know, the people who are sitting there and are signing us in, these are our neighbors. You know, we know these people. And at one point, people did have to show something when they registered, whether it was a piece of mail that showed their address, et cetera. But the point is that there's not much proof of in-person voter ID fraud. You know, people talk about this a lot, but it really doesn't happen much, and there are criminal penalties that are available to pursue if it does happen. We don't need all these voter ID laws that pushes citizens out of the voting processes. So, as I say, it's a solution in search of a problem.
I happen to totally agree with your point of view, I'm raising these questions because some of the people who are saying we need to do this, we need to protect our country
Right.
from these immigrants, from these people who are abused. But my position is that the reason they're really doing this, and most of them vote for Democrats who are interested in progressive causes.
Well, that's right. And the other thing is this. Look, it's not that I or we would be opposed to any and all voting ID requirements. The question is how do you make it available to everybody, no matter what their situation is? How do you make it possible for a poor and an elderly person in a nursing home to register? And if we find ways to address those problems, if we go to them, for example, and make sure that we register them and we use a variety of proofs, that in a fair and even-handed way, maybe some of these voter ID laws should be sustained. But right now, I'm very clear, and as just as you said, Dr. Brown, what they're trying to do is keep some people out of the process, and they're trying to keep them out because of the way they vote and who and what they are.
Now, given the composition of the present Supreme Court, what do you think will happen? I know it's hard to predict what the court's going to do.
It is hard to predict, but I can't be sanguine. That is to say, I think there's a good chance that we're going to see some damage done here. Chief Justice Roberts has, as I said, signaled his opposition. The key vote on this court is Justice Kennedy. He's viewed as the swing vote. He is very conservative, even though he happens to be the swing vote on this court, but that simply says that the court is a very conservative court. And we can hope that we can get his vote, but usually in cases involving issues of race, Justice Kennedy's vote is not a vote that we've gotten, although he has said some things that make it clear that he's not willing to go as far as the other four most conservative justices.
Which includes one black man.
It does. So Roberts and Alito and Thomas and Scalia, he doesn't go quite as far as they go, but he goes pretty far. So this is going to be a tough one, and it's not the only race case that's vitally important that's up before the court right now.
Now, the one that you were involved in at the University of Michigan, challenging affirmative action programs in colleges, higher education.
That's right.
That's coming up.
That's being revisited now in a case that comes out of Texas involving the University of Texas called Fisher versus the University of Texas. And
what was the name of it?
Fisher.
Oh, Fisher, that's right.
Abigail Fisher is a white woman who applied to the University of Texas, didn't get in, and her claim is that it was because she was white. I think that the claim is patently absurd given the facts of the case. She ended up going to Louisiana State University, has graduated by now, but claims that somehow or another she suffered damage by not getting into UT. There are a lot of ways that the court could have avoided and can still avoid deciding this case. But again, this is a court that's very conservative. It's different from the court that was in place when the University of Michigan case was decided. And it may be that the change in the court is the reason that they're going to revisit this issue. Again, I'm not sanguine about the outcome of this case, and I think a lot of damage can be done here. I don't like the facts of the case. I wish the University of Texas had done some things differently, but that doesn't mean that her claim is a strong and a good one. So one fact that'll keep in mind is that that says it all as far as I'm concerned, is that there were many white students with lower test scores and lower SAT scores, standardized test scores, and grade point averages who were admitted as compared to Abigail Fisher. And there were many black students with higher scores who were not admitted. And so if you just think through that, whatever reason she didn't get in, it's not because she was white. That's absurd. Most of the students who are attending UT are white.
Now, isn't Texas a state that had the 10% rule, that if you're in the top 10% of your class,
that's right.
you go to the university?
That's right. It's involved in this case. What happened was that after there was a case that could have gone to the Supreme Court instead of the Michigan case called Hopwood in Texas in the mid to late 90s. And in that case, the Court of Appeals for the Fifth Circuit said that affirmative action in higher education was unconstitutional unless there was a proven specific violation that they were attempting to remedy. And one could say a whole lot more about that, but in reaction to that, the Texas legislature passed the 10% plan and enacted this law that said if there were, that the top 10% of any and every public high school class would be admitted to UT. And so what that did, if one thinks about it, is it instantaneously created a political constituency for that 10% plan. No matter what happened, the Texas legislature wasn't going to undo that 10% plan. And the reason that it produced diversity, and this is why they passed it, was that it relied upon racial segregation and residential patterns. And so while it was purportedly race neutral, everybody knows that the only reason it works is because of racial segregation. But beyond that, it also reached into a lot of residential areas, poor white areas that had never sent anybody to UT. And as I said, it created that instant political constituency in support of the plan. Now, after the Michigan case, which is being revisited in this case, but after the Michigan case, you know, Texas could have dropped the 10% plan and just simply gone with Michigan-type general diversity. It didn't do that because of the political constituency, I said, that had been created. So in the meantime, the University of Texas, they hate the 10% plan because it takes away a lot of discretion. They want to be a national and international university, and they end up with 80% of their class being filled through the 10% plan. It takes away a lot of discretion, as I said, in whom to admit. But this case is about the remaining 20% or so. Actually, they've changed the numbers, the percentage that's covered, but it's about the remaining students. And there they tried to use Michigan diversity for reasons that we don't have time to get into, and that's what's at issue here in this case.
Well, you were the director counsel of the Legal Defense Fund before you went to Columbia. How have things changed legally in terms of the African American and minority community since you were the director counsel of the Legal Defense Fund?
Well, obviously, you know, we have an African American president.
How did that happen?
You know, the country changed, the demographics changed, the hearts and minds of enough white voters changed, and he's an extraordinary individual who had the, you know, the dream and then worked to do what he did. How did it happen? Sometimes I still wonder about that, but there he is, something I never thought I'd see in my lifetime, and I suspect you never did either. Maybe you did.
Well, actually, I worked for Jesse Jackson, running for president.
Right.
In 2 elections, I was a candidate, a representative for him in the Democratic National Convention. And we almost got there, and our point was, let's have a national discussion about our issues. And his point about keep hope alive was really what Obama built on.
That's right. That's
hope.
Right.
Remember the signs that said hope?
That's right. Hope. That's right.
And despite what the billionaires say, most Americans, white and black, are not rich. And they realize that they want an equal playing field. And that's what I think he's represented.
Well, you know, his election and his re-election, you know, we're going to be analyzing this for a long time to come. But the country's changing, you know, demographically and otherwise.
Has changed.
And that has a huge amount. I mean, if you look at the numbers in terms of who voted for him and who didn't, you know, the South, you know, is still a tough nut to crack, even though he was able to win Virginia and, you know,
North Carolina.
You're right, but it's still, if you look at the patterns there, the reason that he's winning there also has to do with demographic changes, more Latinos, African American turnout, and enough white turnout. But the majority of white voters in those southern jurisdictions are not, they did not vote for Barack Obama either time. And so you still have racial polarization in voting as a factor. It just doesn't have the same impact that it once had. So a lot has changed. Barack Obama's president, but also the court has changed. And the court is more conservative. Actually, that wasn't so much since I left the Legal Defense Fund, because while I was director counsel, we opposed the nomination of John Roberts to the Supreme Court. We knew he was going to be confirmed, I should say. But the reason that we had to oppose him, unfortunately, was because of his record. We couldn't look at that record and say, he's going to be confirmed, so let's not oppose him. You know, we had to do whatever we had to do on our watch, bear witness, and I wouldn't be able to sleep very well right now if I knew that this court was as tough on civil rights for African Americans, Latinos, people of color, that John Roberts, Samuel Alito, whom we also opposed based upon his record, that we hadn't said anything. We did everything that we could. They were confirmed, and now they're there. We've now seen that they've struck down voluntary school integration efforts, unconstitutional, and we see this case before them, the voting rights case, the Fisher case, and there's another Fair Housing Act case that they may reach out and decide in an adverse way. They can do a lot of damage this term, but the country continues to change.
Well, the demographics are such that by 2035 or something like that, people of color will be in the majority of the population. Last year, there were more minority births than there were white births.
That's right.
And that might account for the backlash from the white population, which raised the question, why are they concerned? Because maybe some of them treated us so badly, they think we're going to treat them the same way. But that's not really true. Even the black political perspective is broadening out. You have black conservatives.
That's right.
And you have blacks who take positions that you and I may not agree with.
Oh, absolutely, that's right. And I should add, though, that since I left the Legal Defense Fund, we did have one addition to the Supreme Court, as you know, my high school classmate, Justice Sonia Sotomayor. So that's a huge change. But you're right.
And Obama will have one or two appointees during his next 4 years.
Well, one never knows, but we
can live
think
a long
there may
time.
be one. That won't change the balance of the court in all likelihood. If it's who we think it might be. But one never knows what's going to happen. But you're right that this should not be. White Americans, I would hope that they would let go of whatever fear they may have about the changing demographics of the country. I don't think anybody's out to do them in. What we want, all of us want, is opportunity, economic opportunity, educational opportunity. We want opportunity not only for middle-class people. I mean, all the political rhetoric goes toward the middle class, and yes, we need to take care of the middle class. They're the backbone of the country. But I think we need to have a discourse about poverty in this country, and we need to have programs that help poor people also. So I would hope that some of the rhetoric that has been so polarizing that the folks who have been responsible for a lot of that rhetoric, they let it go, and we figure out how to collectively approach some of the problems that we face as a country.
Just as the things have changed in regard to race and the legal opportunities to oppose segregation, sexual orientation is something that's brought many of the liberal whites and sometimes conservative whites into this, because it does have to do with the rights of individuals. The Constitution says every man is treated equal. The only thing they didn't say is every man. They left out women, and they didn't say every white man.
Right.
So the Constitution, Second Amendment, something was done when the country was a rural place, a totally different place. The main concept of the Constitution was the concept that people could get together and decide their destiny. The problem is that many times when it was black people, they didn't want to go with it.
Well, the original sin for this country was slavery, and we put that issue behind us, although we still have a legacy that needs a little bit more work. But the Constitution, of course, didn't say anything about sexual orientation. Now we have cases up before the Supreme Court having to do with the right of people to marry, even if they're same-sex marriages. Who would have thought, 20 or 30 years ago, that we would see the change that we're seeing? Some people are afraid of it. Other people embrace it. But by now, and even a lot of African Americans first said, look, gay rights, you can't compare it with the civil rights movement. You shouldn't compare it. But the country is changing in attitudes. The majority of people support in this country now, support gay rights and maybe even same-sex marriage, if I understand it correctly. And that change is going to continue. You know, many Americans, a significant number of Americans, are gay or lesbian. You know, for many, many years, for centuries, they lived in the shadows. And they're saying we don't want to live there anymore, and we don't want to be discriminated against. And if we think about our families, you know, these are family members. Yeah, there's a lot of change going on, and there's going to continue to be more change.
All these things bring up the question of democracy. Does 51% really rule the other 49?
Right.
It's a good philosophical question.
It is. And, you know, we believe in collectively in democracy, but democracy is messy. You know, it's always going to be messy.
That's what President Obama said in one of his talks.
Well, that's right, and he's right about that. He's right about that.
When you try to get a consensus, it is difficult to get a consensus.
That's right.
Let's take sports. You know, I'm a Jet fan, you're a Giant fan. Who's going to be on top? That's not important. You can argue about that. But about legal rights and voting rights and student rights, we have to argue about it. Today on African American Legends, we've been talking with Professor Ted Shaw from Columbia University, talking about the struggles of African Americans in the courts. Thanks for being with us today, Ted.
Thank you for having me with you.